Hi there, welcome to third video in this series where we are looking at a couple of takeaways from the Department for Community or the government guidance for Northern Ireland for house moving during the coronavirus pandemic. And as I said yesterday, we're going to have a look today at how the Law Society of Northern Ireland has responded to that by drafting a set of coronavirus special conditions, ostensibly for the profession, but obviously indirectly for the direct benefit of buyers and sellers and developers as well. So we know, even from the last couple of days from talking about it, we know that one of the real sort of thrusts of the government advice and guidance is that we need to try to get flexibility into the process. And even though, as I said yesterday, the actual specific guidance to conveyancing solicitors from the department is actually very light. Law Society has been keeping really, I suppose, over the last period of lockdown, has really been pushing forward with conveyancing updates through its e-informer to conveyancing practitioners in Northern Ireland, and that guidance has been ongoing. So the coronavirus special conditions very much reflects the thrust of the guidance being that we have to have flexibility in the process. And I suppose direct or indirectly, but the main benefit is obviously to buyers and sellers, but it also assists practitioners that we have a sort of a standard set of special conditions. Otherwise, I'm quite sure that we would all then have to essentially individually negotiate a set of special coronavirus conditions in each and every case, which would be an absolute disaster. So I thought we would have a quick look through them. They are about 2.5 pages long, three pages long, which is quite short for a set of conditions in conveyancing. The one thing I would say is, if you look at the rider put forward by the English Law Society for, this is for contracts which have already in England been exchanged, and it's basically the parties getting together to agree like a separate agreement where they agree to be flexible and agree not to hold each other to some of the more draconian terms of conveyancing contracts. As far as I can see, the English rider only has 4 or 5 potential coronavirus events where the trigger is put in place for this flexibility to happen, and for some of the other sort of enforcement clauses to take effect. In Northern Ireland, we actually have 13 coronavirus events, and I must say I'm very pleased to see that, because that takes special cognizance of the fact that I think during lockdown we as conveyancing practitioners and therefore our clients have had a more difficult time than the rest of the UK because of some of the things that have happened, and our special conditions actually take account of that. Just to go through them very quickly, a coronavirus event, and we'll talk in a moment about what happens when you have a coronavirus event. It's the usual ones you would expect. It's illness, self-isolation, quarantine of either the vendor or the purchaser or anyone living with them, and that has to prevent the physical process of moving. Any requirement of the regulations or any mandatory guidance. So essentially, if there's any lockdown, that would be a coronavirus event. A couple of the ones which I think aren't necessarily in England, but we have here, and that I believe is a direct result of things which have happened to conveyancing solicitors over the period of lockdown. So a withdrawal by a lender of finance or the expiration of any offer of finance required by the purchaser to complete under this contract. And again, we have had lenders at the start there of the lockdown simply withdrawing their mortgage offer. In one case, they actually refused to release mortgage funds to us because they just didn't like it anymore. So as I say, that's why that's in. Inability or unavailability of a contracted removal firm. I think that's probably raised some eyebrows, where a removal firm, you can't get a removal firm to move you on the day of completion. This very much, I think, harks back to, right, again, at the start of lockdown, I think it was a British Association of Removers basically told their members that they shouldn't be going into houses. So I think that reflects that sort of idea where you simply cannot get a removal company anywhere because they're not allowed to do it. Inability or delay in carrying out third-party pre-completion inspections. That comes back to the survey thing. Hopefully that won't be an issue now because that sort of is cleared. Inability or delay in obtaining necessary searches, property certificates. Now that was important because some of the offices had closed or were in very limited capacity, and some of the data was out of date because it wasn't actually being updated on a daily basis. Inability in having any of the documentation correctly executed or witnessed by a party. That's a really important one. Solicitors put themselves under very onerous obligations and undertakings to get various documents executed or to produce various documents properly executed. Doing that with not a huge amount of confidence that you know exactly when that might happen is a bit risky. So again, that allows for that, which I think is quite a good one. Any other ones of note? Oh yeah, the ability of the Northern Ireland banking system to transmit funds to facilitate completion on the day of completion specified by this contract, and that ability is compromised. Well, that speaks for itself. I've talked about this many times, and the inability of the Northern Ireland banking system to move funds about. So here we actually have it as a potential coronavirus event, which I think is a very, very good thing. What else? Again, failure of funds being released in time for completion when requested from the purchaser's lender. We've had this issue before. I mentioned it yesterday. We're one of the main high street lenders. One of our funds didn't turn up, and we rang them and they just simply said, I'm sorry, we've done enough telegraphic transfers today, try again tomorrow. And the final coronavirus event is not if something happens in your transaction, but if something happens to another party somewhere else in the chain, then it takes effect. If a coronavirus event happens, then there are two main effects. First of all, essentially the parties are not allowed to go down the default route and suggest that there's going to be a breach of contract and there's going to be compensation sought and things like that. And the second one is that the completion can be delayed. The completion date should be agreed between the parties. I would expect you're probably talking 14 days to allow for self-isolation. There is a long stop date of 30 working days if you can't agree, but I think most people are going to agree the shortest possible time, which is going to be 14 days. The other thing then, if a further coronavirus event occurs sort of while you're in the middle of another coronavirus event, then the whole thing can be reapplied again. Hopefully unlikely, but it covers all of the bases. The guidance from the Law Society does point out that the draft isn't prescriptive, it can be adapted. Certainly there's some things in and around mortgage expiry dates and long stop dates and things like that that might be important. If there's not a chain, then you can obviously take out the clause about the chain. All in all, but this is a really strong set of conditions. It goes much further, I feel, in the English ones. The English ones are, in any event, intended for parties which are already in completion. But as I say, these special conditions, I love them because I think that they are very Northern Ireland proof. They have taken account of the experiences that we've had during lockdown. One of the massive advantages of having a smaller profession in Northern Ireland is that we can get really important feedback on our day-to-day toils and travails to the Law Society and allow the committees in there and the people in the Law Society who are doing this stuff to actually respond to our sort of day-to-day pains on the ground. So as I say, this is a particularly good set of special conditions, and going forward it will allow, I feel, parties to get into contract with a degree of confidence, knowing that there is flexibility if any of these unlikely events occur. So obviously this week we're focusing on the property market reopening. I'll be back tomorrow to talk about some of the other takeaways in the government guidance, but I did want to pause and just sort of talk today about the special conditions, because we're going to be seeing these a lot, I think, in pretty much every transaction. These also are going in building agreements as well. Developers are included in this requirement for flexibility. So as I say, hopefully this will give confidence to parties to move forward, and more tomorrow. And as ever, Thank you for your comments and your likes and your engagement.